Pulling this up. Yep. Sorry, just one moment. Okay.
Great. Thank you. So first off, apologies. We should have shared a much more truncated bio for both Jacqueline and I to jump into the meat of the presentation. So we'll be sure to prepare that should we be invited back. So we're excited to talk to you about artificial intelligence in healthcare and specifically the federal and state policy activity to date, mainly focusing on the end of 2023 and into the second quarter of 2024. So if we move to the next slide, we know that everyone on this call is likely very familiar with things that artificial intelligence are good at, as well as their known issues. We put this here just sort of as a level setting slide, but also want to note, I think on the right-hand column, the reason why we want to draw your attention to some known issues in AI is because as we start to talk about where federal and state activity has been, they're sort of circling around a few of these known issues in order to try to mitigate those issues through laws, regulations, and policies. And what we're seeing the first sort of round of activity to be focused on is addressing concerns related to bias and discrimination and transparency. I think the known privacy and security issues, I think, might be less of a focus right now because the existing sort of privacy and security framework continues to apply to artificial intelligence. It's just sort of there's a heightened risk related to privacy and security or slightly different. And similarly, some of the coding and payment concerns related to using artificial intelligence relate to issues that are already a concern within the ecospace. So whether that's potentially causing, upcoding or potential fraudulent documentation to be generated, those concerns are not necessarily unique to artificial intelligence. And so again, there's sort of been less of a focus there. And I think the liability issue between, us is just kind of too hard to tackle at this moment. And so we're not seeing a lot of activity there, although we will talk a little bit about some of the statements around in particular OCR when addressing some questions around use of artificial intelligence by providers, sort of made a comment with regard to not shifting liability. They're not going to allow the liability to be fully shifted to the developers. So with that, let's jump in. So if we start at the federal level, this is sort of a laundry list of the activities to date that we're going to go into more detail on. So we're going to talk about the White House executive order. We're not going to really talk about what Congress has done because they haven't really done much. They, have formed a bipartisan task force on artificial intelligence earlier this year, and there's been a proposed bill to create a national artificial intelligence commission. But so far, we're seeing some activity be proposed, but nothing that, from our perspective, is getting a lot of legs specific to the healthcare industry. And then we're going to go into depth on these other items. So if we move to the next slide, as most of you probably know, back in October, President Biden signed an executive order on the safe, secure, and trustworthy development and use of artificial intelligence. This was a 110-page order that addressed a wide range of AI-related challenges and proposes a coordinated federal government-wide approach to promote safety, privacy, equity, innovation, and international cooperation while ensuring responsible government use of artificial intelligence. This built on the previous artificial intelligence pronouncements by the executive branch, which included the Blueprint for Artificial Intelligence Bill of Rights, and another executive order directing agencies to combat algorithmic discrimination. There's been a flurry of activity to meet the timelines that were set forth in this executive order. Recently, in response to the executive order and pretty specific to healthcare, is that the Department of Health and Human Services issued a plan for promoting responsible use of artificial intelligence and automated and algorithmic systems by state, local, tribal, and territorial government in public benefits administration. And so this would apply to the use of AI by Medicaid agencies, which may have downstream effects on providers who participate in Medicaid, as well as Medicaid managed care plans. While it's merely guidance at this point, that document does recommend that states begin to comply with this guidance because they recognize it's going to take substantial change within the state to meet the vision of this document, and they intend to engage further with stakeholders on this effort. So I think we will see potentially more guidance related to state Medicaid agencies' use of artificial intelligence as it relates to not only benefit administration, but administration of the Medicaid program. On the next slide, there's a few areas of the executive order that are specific to healthcare, because most of them are not. One is around the responsible deployment of artificial intelligence in healthcare that required the department to form a task force on artificial intelligence. The Department of Health and Human Services did establish an AI office with the primary functions of being to drive implementation of its AI strategy, stand up a governance structure, coordinate response to AI-related federal mandates, and foster collaboration across the different agencies and offices within the Health and Human Services. The executive order also instructs agencies to enforce existing laws to mitigate artificial intelligence practices that result in unfair and deceptive business practices, privacy violations, and discrimination. So this is leveraging laws we already have, like HIPAA, the FTC prohibition on unfair and deceptive business practices, 1557, et cetera, to mitigate risks of artificial intelligence. And these directives would apply broadly to oversight and enforcement with regard to healthcare providers and insurers who might use artificial intelligence. There was a directive for federal agencies to foster innovation through offering research grants to study artificial intelligence. So clearly, there is money that's needed in order to for researchers and academic medical centers to actually be able to afford to perform the research. And then a collaborative effort between Department of Health and Human Services and the Departments of Veterans Administration and Defense to create a framework to identify and log clinical errors resulting from artificial intelligence in the healthcare settings. The next slide, we're going to talk about the 1557 regulations, where the Office of Civil Rights issued regulations that impact the use of artificial intelligence in healthcare. And we understand that you've actually covered this topic in a prior meeting in detail and had conversations with the Office of Civil Rights with regard to some questions. I'm going to just briefly touch on this in case some of you were not able to participate in that conversation. So in April, the Department of Health and Human Services finally finalized their anti-discrimination regulations that implement 1557 of the Affordable Care Act. This, as one small component of this broad-reaching regulation, there are about 30 pages that were dedicated to prohibiting discrimination through the use of patient care decision support tools. This was defined very broadly in the rule, and it includes any automated and non-automated tools, mechanisms, methods, technology, or a combination thereof used by a covered entity, and we'll talk about what that definition means, that's used to support clinical decision-making in its healthcare programs or activities. And the tools that could be impacted range from flowcharts to clinical guidelines to complex computer algorithms and decision support interventions and models. This rule impacts all covered entities, which also the definition got expanded under this rule, and it includes any provider that essentially accepts Medicaid, Medicare Part A, Part B, as well as Medicaid managed care plans, as well as a whole host of other types of entities that fall under that definition. And covered entities subject to the rule are prohibited from discriminating against based on a variety of factors, and expressly can't do so through the use of patient care decision support tools. The final rule doesn't specify specifically how covered entities must identify and mitigate the risks, but the OCR did say that they would take into account certain factors when assessing whether or not the covered entity appropriately identified and mitigated the risks. So they will look at the covered entity size and resources, whether the covered entity used the tool in a manner or under the conditions that were intended by the developer, or whether they customized the tool, whether the covered entity received product information from the developer regarding potential discrimination, and whether the covered entity has a methodology or process in place for evaluating the patient care decision tool that it adopts and uses. The OCR will enforce compliance, and they stated here that there is no defense to blame the tool developer, and OCR expressly rejected a suggestion that liability with regard to the use of the tool be shared between the developer and the provider, or that developers somehow be subject to strict liability. Moving to the next slide. In December of 2023, the Office of National Coordinator issued final regulations related to AI transparency and risk mitigation requirements for certified HIT developers. So just to be clear, because there's a lot of misunderstanding about the scope of this regulation, this regulation solely applies to essentially electronic medical records that are certified for meaningful use. So this regulation does not apply to homegrown technology or chat GPT that might be used by a health system if that is not integrated as part of the offering by the certified health information technology. And so the purpose of this rule is to promote development of algorithms that are fair, appropriate, valid, effective, and safe, and to ensure that artificial intelligence used by healthcare providers can be trusted. This imposes requirements on these developers of certified health information technology. So this is like the Epics and Athena Health of the world that use predictive decision support interventions. It has two main requirements. One is around transparency to ensure that the user knows the purpose of the intervention, the funding source for the intervention, exclusion and exclusion criteria in the training set, the process used to ensure fairness in the development of the intervention, and a description of the external validation process. It also has a risk management component that requires that the predictive decision support intervention must be subject to analysis of risks and benefits related to validity, reliability, robustness, fairness, among others, that it practices to mitigate risks, and that it's developed policies and procedures for controls for governance in terms of how the data is acquired, managed, used. The ONC indicates that the purpose of these requirements is to promote the development, as we note above, of a fair and appropriate valid algorithms. We note that HHS recently issued a proposed HIT2 rule. We're still going through that rule. It's quite voluminous, but do flag that it does have some technical requirements that are being proposed on clinical decision support interventions that may require certain of these transparency requirements to actually be disclosed when the user interacts with the decision support. Going on to the next slide. The FDA has been the agency most vocal about regulating artificial intelligence and has been well ahead of other agencies, including by issuing several non-binding guidance documents and informal statements. How much authority the FDA may exercise over artificial intelligence is dependent upon whether the technology itself is considered a device, and the definition is on this slide, and whether that technology is incorporated into a device's operation, or if artificial intelligence is being used to develop or evaluate the efficacy of drugs or biological products. Most recently, the FDA has stated its commitment to coordinate among various internal divisions and work together with other federal agencies to develop and implement a harmonized approach to the AI regulation. Because if we turn to the next slide, we can see that the FDA was well out front. So to date, the FDA has taken many notable actions to articulate its approach to AI oversight. For instance, it most recently issued a discussion paper for the proposed regulatory framework for modification to artificial intelligence machine learning-based software as a medical device, which builds upon its 2021 AI ML software as a medical device action plan. Together, these documents demonstrate the agency's longstanding and continued commitment to support innovative regulatory frameworks governing medical device software and other digital health technologies. The FDA has also published 5 additional documents addressing machine learning and AI, and it plans to release an artificial intelligence drug development guidance document later this year. This guidance will likely expound upon the FDA's plan to develop and implement a flexible, risk-based regulatory framework for drug development, as it initially indicated in its prior guidance. The FDA commissioner recently remarked that given all this activity, the FDA needs more resources and authorities to adequately oversee artificial intelligence and machine learning in healthcare devices and drug development. On to the next slide. This is a regulatory guidance that impacts Medicare Advantage plans. So in February of this year, CMS published a response to a frequently asked question regarding the use of algorithmic decision-making and artificial intelligence in coverage determinations related to medical necessity or prior authorization or appeals. That guidance clarifies and sort of underscores what was included in the commentary to the final rule that was issued, I think, in 2022, that Medicare Advantage plans can use algorithms and software tools so long as it's only an assistance device. But ultimately, for each determination, there must be individual review if it's affecting clinical coverage. And so it does need sort of a physician or whoever is the appropriate clinical reviewer to make the ultimate decision. And we actually see a proposed bill codifying similar principles in California right now that we think is likely to pass. I also just flag here that there's a lot of pending litigation from the Department of Justice over the alleged use of artificial intelligence to deny Medicare Advantage claims. We move to the next slide. The Federal Trade Commission has also sort of started to make statements about regulations of artificial intelligence. They have jurisdiction to regulate deceptive and unfair business practices and are agnostic as to the industry, and they can enforce laws and regulations governing consumer protection and competition. They maintain the same authority with regard to deception and unfairness for old advertising claims as they do now as it applies to claims made by advanced technology products. And so conduct that may violate the FTC Act as it relates to artificial intelligence is misrepresenting if a product is using artificial intelligence, exaggerating claims that a product that uses artificial intelligence, exaggerating the claims with regard to what the product can do, such as stating something like it's smarter than a human without some sort of proof that that's the case, failing to make clear to consumers when they're interacting with an artificial intelligence system, such as a chatbot. And so while Jacqueline is going to talk about some state laws that require disclosure related to interaction with a chatbot, even in absence of those laws, the FTC could find that you violate unfair and deceptive acts and practices and affecting commerce if that disclosure is not made. They also note, like everyone else, that it could violate the FTC Act if the system itself has a discriminatory impact. So this is another feather, I guess, in the government's cap in order to go after an algorithm that has discriminatory impact. And if you deploy artificial intelligence systems before taking appropriate steps to assess and mitigate risk. They've also provided their own guidance around how to mitigate risk of artificial intelligence and discrimination and mitigate the risk in terms of potential violations of the FTC Act. Lastly, just want to touch on the implications of the overruling of the Chevron doctrine and how that might affect artificial intelligence. So by way of background, the Chevron doctrine was a sort of long-standing doctrine that came out of a case where a federal agency, if a federal agency is challenged in a court, and depending on the statutory interpretation, the court is supposed to determine whether the statute's ambiguous. And if the statute is ambiguous at all, it would defer to the agency's reasonable interpretation of the statute, even if it's not the best interpretation in the view of the court. The Chevron doctrine makes it really hard for a provider, for instance, to challenge how a federal and a state agency has interpreted regulations and federal statutes and state statutes if so long as that agency's interpretation is reasonable, even if it's not the best or the most plausible interpretation, if it's reasonable at all, the court was supposed to give deference. And this was thought to sort of balloon the authority that is being given to agencies and make it very, very hard to challenge an interpretation by the agency. Loper Bright, which is a recent Supreme Court case, overruled the Chevron doctrine. And so now under this new case law, when a court reviews an agency's interpretation of a statute, the court determines the meaning of the statute based on its interpretation without this deference to the agency's interpretation. However, if the Congress delegates fact-finding or policymaking to an agency, then federal courts may still give deference to the agency's determination. So what does this mean in plain language? In terms of sort of broad implications for the healthcare industry, this is likely going to shift responsibility for policymaking from agencies back to Congress. It may be more challenging for agencies to sort of help fill in the gaps to issue guidance when statutes have been written very broadly. It also will make it challenging potentially for agencies to sort of reinterpret the statutes for modern scenarios or novel scenarios if those scenarios are not expressly discussed in the original law or they didn't exist at the time that the law was created. It also is going to shift interpretive authority away from agencies and towards the courts, which critics fear could destabilize policymaking by increasing the volume of administrative litigation, as well as the uncertainty over whether new agency actions will be permitted to take effect or whether long-standing policies will be permitted to remain in place. I think a recent Forbes article summarizes a few key points regarding the fall of Chevron and AI regulation very, very well. So in the wake of the Loper-Bright decision, it would be really up to Congress to explicitly define the scope of authority granted to any future designated artificial intelligence agency or legislation granted to an existing agency, significant authority to regulate artificial intelligence. And so Congress is going to be able to define the scope of what an agency is able to do or not do. Once an agency has been designated by Congress to oversee artificial intelligence, if that happens, it's likely to be broad and explicit, or it will have to be explicit in light of Loper. And it would be explicit authority to act. And you know, the comments there is that in this particular instance, in artificial intelligence, where it's highly specialized, this is an area where we actually probably would have preferred Chevron deference, because regulators targeting artificial intelligence, we want them to have deep subject matter expertise, which is unlikely to be found in the members of Congress who are passing these broad legislative mandates. We also want agencies to be nimble and to be able to consider the rapidly evolving circumstances surrounding artificial intelligence, have flexibility to issue guidance or change guidance. And agencies are much more nimble than Congress to frequently and quickly update rules. But it's all, you know, this is all sort of up in flux and remains to be seen. But this is sort of our current thinking on how the Chevron doctrine may impact AI activity at the federal level. And with that, I'm going to turn it over to Jacqueline. Oh, one other national. I'm going to turn it over to Jacqueline to talk through the next slides.
Thank you, Randy. So just briefly in sort of other national news, in April of this year, the Federation of State Medical Boards, or the FSMB, published a report that outlines recommendations for physicians and state medical boards in navigating and governing the use of AI in healthcare. The report has 6 distinct sections that are outlined here, which include strong language to underscore the FSMB's perspective that physicians are ultimately responsible and liable for the use of AI in healthcare and clinical decision-making. Just as an example, in the education section of the report, FSMB says that a physician has the duty to maintain the requisite skill and knowledge to provide safe and effective healthcare. And in the accountability section, they state that a physician must, quote, accept responsibility for responding appropriately to the AI's recommendations. I would just note that while this language is specific and strong, it is worth noting that the FSMB is a body that supports and represents state medical boards. They do not have regulatory authority over physicians. So this is simply a set of recommendations for physicians and ultimately state medical boards to consider. State medical boards routinely hold physicians accountable for care delivered to patients. So these recommendations are not necessarily out of step with current expectations related to responsibilities that are placed on physicians within the context of patient care. Let's dig in now to some state-level AI policy activity that we've uncovered through Manatt's ongoing AI policy tracking efforts. Through our analysis, we have found that bills passed prior to 2024 tended to be relatively specific. And 2 examples we wanted to highlight here are from California and New Jersey. Both of these states passed what we'd call narrow, quote unquote, bot laws that Randy referenced before. So in California, they passed a law saying that it is unlawful for a person to use a bot to, 1, communicate or interact with another person in California online, 2, for the purpose of knowingly deceiving the person about the content of the communication in order to incentivize a purchase or sale of goods or services, in a commercial transaction, or to influence a vote in an election. However, there is no liability if there is a disclosure that the person is communicating with a bot, but the disclosure must be clear, conspicuous, and reasonably designed to inform persons with whom the bot communicates or interacts that it is in fact a bot. In New Jersey, the bill language states that a person cannot use an online tool to communicate or interact with a person in connection with the sale or advertisement of any merchandise, unless the person discloses at the outset that the communication is being conducted through a bot. States have also passed some more bills that are specific to healthcare, such as allowing AI in conducting eye exams and the use of algorithms to support mental health medication utilization or to alert practitioners of potential opioid overprescribing. For more on pre-2024 laws, as well as the current state of AI state policy activity, we'll dig into that a bit more in the next few slides, but we have provided a link at the bottom of the slide to Manatt's AI policy tracker if you're interested in some more details. So let's turn now to see sort of what's been going on since the start of 2024. The map on the left-hand side of this slide indicates all of the states that have passed or introduced a bill this year that either directly implicated the use of AI in healthcare or would inform the use of AI in healthcare. And we've lifted up here on the right side sort of 4 key trends that we are seeing from the activity that we've uncovered. So the first major trend that we would flag is that the majority of activity so far this year is really related to states that mandate that a state study AI, develop AI working groups, or draft reports on AI to inform future policymaking. The second major trend we're seeing is that many states are introducing bills addressing transparency concerns. And that includes transparency between those who develop AI tools and those who deploy them, those who deploy them and those who use them or end users, and or between those who develop or deploy them and the state. As the year has gone on, we have definitely seen an uptick in the number of states implementing bills with transparency requirements between deployers and end users. The third major trend that we're flagging here is anti-discrimination, which Randy touched on a bit at the federal level as well. Almost a dozen states this year have introduced legislation that included requirements explicitly focused on prohibiting or addressing or minimizing discrimination by AI tools. And then finally, only a handful of states have introduced legislation specifically targeting healthcare use cases, such as the provision of AI in health insurance coverage or clinical decision making. Overall, so far this year, 13 AI-related healthcare bills have passed. We're going to cover 3 of them in a bit more detail here. And the majority of those that have passed have been related to the state activity trend, the number 1 trend on this slide. So this is, of course, a very high-level overview, but as you can see on the right-hand side, many of the past bills related to state-mandated study bills, working groups, or reports on the use of AI. So just a few examples. So Colorado, West Virginia, Oregon, Indiana, Tennessee, and others have passed bills to establish forces focused on AI. We've done an in-depth analysis of these bills. The charge and the members of these state-appointed task forces vary, but some are specific to healthcare and some are a bit more general. So just as an example, Florida established the Healthcare Innovation Council, which specifically is aimed to convene subject matter experts in an effort to improve quality and deliver the delivery of healthcare, including by leveraging AI. West Virginia, on the other hand, established the West Virginia Task Force on AI. This is not specific to healthcare. Rather, the task force is charged with developing best practices for public sector use of AI, making recommendations for protecting individual rights related to AI, and taking inventory of current use cases of AI across state agencies. And while the charge of the task force is not specific to healthcare, the bill does stipulate that the Secretary of Health or their designee must be a member of the task force, as well as someone who represents West Virginia health systems. I would also note here that this trend of states passing bills requiring the establishment of focused task forces or the development of studies or reports is not a new concept. This is actually something we've seen a lot in the telehealth policy world. Often when states are in the early stages of determining how to design their state policies regarding the use of new technologies, they might start by convening a group or conducting a study that will ultimately inform their future policy decisions. So there are 3 states in particular that have passed or introduced legislation so far this year that you may have heard about in the news that we'll dig into a bit more here, Utah, Colorado, and California. So let's start with Utah. Utah passed a law back in March that focuses on disclosures between AI developers and end users. The act places generative AI under its Consumer Protection Authority, which requires that generative AI comply with basic marketing and advertising regulation. This law requires quote unquote regulated occupations to disclose that they are using computer-driven responses before they begin using generative AI for any oral or electronic messaging with an end user. This includes the use of chatbots, appointment schedulers, and customer service responses. Notably, regulated occupation includes a wide swath of healthcare professionals, such as physicians, surgeons, dentists, nurses, pharmacists, midwives, dietitians, radiology techs, genetic counselors. Over 30 different healthcare professionals are called out in this law. Finally, the law states that there is no defense to argue that the generative AI, and in this case, not the company, made a statement or violated consumer protection laws. So next, we're going to look at Colorado. Colorado passed a law back in May that imposes significant transparency requirements on developers and deployers of, quote, high-risk AI systems. Developers and deployers are broadly defined and would include healthcare stakeholders such as hospitals, insurers, and digital health companies who develop or deploy high-risk AI systems if they are not otherwise exempt. Under this law, developers are required to mitigate algorithmic discrimination by using reasonable care to protect consumers and ensure transparency between developers and deployers, the public, as well as the Attorney General. Developers can address this by making a variety of specific information available to deployers, posting a public statement on a website that summarizes the types of high-risk systems they've developed, and by sharing foreseeable risks with the Attorney General in a format that has not yet been determined. The bill also requires that deployers mitigate algorithmic discrimination, create and implement a risk management policy and program, complete impact assessments, and ensure consumer transparency. There are several exceptions under this law, most relevant to healthcare. Deployers and developers and deployers are exempt if they develop or deploy a high-risk system that has been approved by a federal agency, such as the FDA, or if they are a HIPAA-covered entity providing healthcare recommendations. Many healthcare stakeholders have logged concerns regarding the breadth of this law, the feasibility of complying with it, and the risk that it might stifle innovation within the state of Colorado. The governor acknowledged when he signed this law that he shared some of those concerns and has urged the legislature to reconsider some of the law's provisions. So while this technically has an effective date of February 1st of 2026, we anticipate that the law in its current form may not be what is ultimately implemented in a couple of years. And then finally, for our state examples, California has introduced an AI bill focused on transparency that would affect healthcare providers and the delivery of care. Assembly Bill 3030 would require a health clinic, physician's office, or group practice that uses generative AI to generate written or verbal patient communications to ensure that those communications include both a disclaimer that indicates to the patient that the communication was generated using generative AI and clear instructions permitting a patient to communicate with a human healthcare provider. So although this bill is not yet passed, this is another, I would say, good example of how states are beginning to regulate physicians and the communications between physicians and patients that utilize AI. And so I am now going to hand it back to Randy, who's going to talk through how healthcare organizations might consider responding to the risks of AI.
Yes, thanks, Jacqueline. And Gil, to sort of answer your question in the chat, I think that a lot of providers and payers are in the infancy, honestly, of thinking about how to monitor their artificial intelligence applications and mitigate risks. Here are some of the things that we are recommending clients do, and where we're seeing some clients begin to develop governance committees and frameworks. But I would say that most of our clients right now are sort of in the process of like inventorying like what artificial intelligence is being used, how does it get its way into the system, what's the approval process, trying to identify like who should be part of an interdisciplinary committee related to reviewing these things, and setting up more of a proactive framework for how they may review requests to use artificial intelligence going forward. I'm not sure that many people yet have figured out how to tackle the fact that artificial intelligence has been used for a very long time by healthcare stakeholders. And when we're using this terminology in these regulations or in these proposed laws and guidance documents, usually they're not limited just to generative artificial intelligence. And so it really, if you're applying them clearly, they really should be figuring out how to go back. You know, with that said, I think the other part, sorry, where people are sort of figuring it out is once we approve it, once we say it's okay to use, how do we monitor it to make sure that as it's sort of it's learning and changing, that we still think it's okay, and who really has the ability to monitor that. So, you know, these are some recommendations, but I realize that actually, like in current organizations, some of them are kind of lofty right now until we can figure out a more efficient way to do it. But you know, having people engage with technology enough to understand the risks and the benefits, so people in a C-suite or people who like in the compliance department or the legal department who are by nature risk adverse, sort of seeing the benefits of the technology, and so they're not just also getting their information from reading, you know, the news about all the terrible things that artificial intelligence can do. Then developing internal resources to start a risk management program. So developing a governance structure, developing a framework of like what types of things are low risk that maybe they don't need to go to the committee. So, you know, we're seeing policies and procedures be developed where, you know, we say, if you're using artificial intelligence to summarize, you know, medical journals for your own use, to then use that to prepare a presentation or to train your team, you can do that. That's pretty low risk. If you're using, you know, it to respond to in-basket messaging, that's administrative in nature, we have this different amount of risk tolerance. And then obviously, if you're deploying it to help support clinical decisions or make diagnostic decisions, then maybe there's a separate process, and trying to get organizations to define a process where it's not a one size fits all, because there are sort of low risk uses of artificial intelligence. Also to figure out how you're going to track uses of artificial intelligence within your organization. So then you can develop, like with your limited resources, which of those need to be monitored and by who and how frequently, and does that monitoring require sort of an audit or a clinical review of the output versus what a human might do without the artificial intelligence, you know, supplementing their work. And then adopting policies and procedures around unique risks of artificial intelligence, you know, whether that's verifications, heightened security standards, a heightened review process, potentially reporting out to the board, modifying contracts to include reps and warranties with artificial intelligence in mind, with sort of SLAs, like you would maybe for a software company related to testing, reporting, transparency, insurance requirements. We're actually working right now on sort of a model addendum that might be able to be adopted. And then, you know, having your vendors perform continuous testing and auditing, and reporting that out to you if your organization doesn't have the capability. We're also seeing organizations contract with third parties to help do validation of both the validity of their algorithm, to assess for bias and discrimination, and to assess also sort of the efficacy of the artificial intelligence. And there are, you know, both free and proprietary services out there to do that. So those are sort of just to name a few, but I think honestly, it's going to take a little while to figure out what works and what doesn't, what's efficient, what's something on paper, but really is a waste of time versus, you know, really effective strategies. Sorry for that very long answer, but I think it's a combination of a whole bunch of different activities.
Thank you. Thanks a lot.
Thank you so much. Yeah. Sorry, are we? I was. We do have some other questions on the chat. I also received another question from one of our core site leads as well, mainly around 1557 non-discrimination rule for AI models. The question is, healthcare delivery organization, are they held accountable for this 1557 non-discrimination rule for AI models that are covered under IRB protection or review?
That's a good question. I don't know the answer. So, I mean, first, just to flag the many components, and in some cases, the whole 1557 rule has been subject to litigation and has been enjoined. But I don't recall there being any sort of carve out from it something that received IRB protection from being not subject to the rule. But I would think that if the IRB reviewed it, and as part of that review, they looked at concerns around discrimination and bias, that would certainly be a risk mitigating factor that you could that would be in favor of the healthcare entity engaging in risk mitigation by having their IRB review it. And we could certainly take a look at the rule and see if they address it. I don't recall that being called out as something that was addressed.
Thank you so much. Murtaza, I think you have your hand up. Please go ahead.
Yes, thank you. Thank you for this excellent presentation. There's a lot going on in the regulatory space. I did have a couple of questions. One's a quick one. The AB 3030 in California, what's the likelihood of that going through? The one about the disclaimer. And then the second question, I don't remember the exact language, but on the Chevron ruling, there was a note towards the bottom that if there is guidance from Congress, investigative or some other direction from Congress to the agency, then the agency's regulations or interpretation is what would supersede. My question is regarding like the FDA, what kind of direction are they given that would be comparable to that section of your slide?
Sure. So let me take the California rule first. So based on my last conversations with others in California who are following this rule, is that it has support, and the thinking is that right now it doesn't have tremendous opposition. They did walk back some of the more what I thought was silly language that would require disclosure, even if the response had been reviewed by a human and edited, because that seems to encompass like every email you write if you use any of the AI tools in Microsoft. But I have not heard that anyone is actively opposing the rule in a way that it would keep it from getting passed, but we are closely monitoring it. So that's to answer your first question. I think the second question, so under Chevron, I'm sorry, under the new sort of the no longer Chevron, what would still exist is if essentially the sort of like in the FDA context where Congress has said, FDA, you have authority to regulate devices. Here's what devices are. So the FDA now has broad authority to regulate devices, and that authority hasn't been limited or potentially narrowed in that statute. They would sort of be able to regulate all components related to that device. But because the statute itself lays out what a device is, they maybe no longer would be able to take an interpretation of what a device may be if it's not clearly within the language of the statute. So in the AI context, they may say, okay, we're going to create this new artificial intelligence agency, and they're going to have authority to regulate artificial intelligence. That would be a pretty broad authority. They could narrow that authority by saying, we define artificial intelligence to only include generative AI. I'm just making that up. That's not what they're going to say. In which case, then that agency wouldn't be able to like potentially find a way to expand their authority through an interpretation to include other types of machine learning.
So like referencing, let's say the 2022 CDS guidance, how much of that So I mean, I know that like the 4 criteria listed are within congressional law, but how much of that would be at risk because of Chevron, and how much of, or would none of it be at risk because there's been some policy making or investigative direction from Congress for that kind of
So-
regulation?
I'd have to go back to the 1557 enabling statute to actually do that analysis, but my gut tells me that potentially it could be at risk. I doubt that 1557 gave them specific authority to regulate clinical decision support tools specifically.
Okay.
So I would have to go back and do that analysis, but it is possible that that is exactly an example that could be shut down, especially if, you know, you went to the court and the court said, you know, we looked at this, we looked at the plain meaning of it. It clearly meant like you can't actively discriminate against patients when they show up for treatment. It did not mean that you have to go through all of your systems and every single workflow and Visio chart you've ever created to see if accidentally something, you know, was resulting in bias.
Okay, thank you.
Mark, go ahead.
Thank you for the incredible presentation. I'm in a vehicle, so there may be some background noise. But Randy, your hypothetical scenario of new authority being granted to an agency to regulate AI, to me sounds somewhat like the announcements that came out today about ONC. So I'm curious what your take is on kind of the restructuring in HHS and the designation of a chief AI officer for HHS and how that's going to broaden ONC to, I think, ASTP.
So I have to tell you that every presentation I have a fear that something's going to happen the morning of the presentation that I am not going to catch because I'm heads down either prepping for the presentation or doing some work. So I actually did not see the announcement. So can I noodle on it and get your email and get back to you?
Of course.
Thank you. We'll take note of that. Jacqueline, did you see it? Okay.
Not yet, but I jotted down the
It didn't
question.
make our way. Normally we have like a flurry of random chats all morning of like news stories that we all pay attention to. And this one didn't make its way to our Teams channel. Any other questions?
Bebe, I know you were tracking questions. Are there any other questions?
Seems like we have one in the chat right now. Oh,
Uh-huh.
it's just a statement.
Just a statement.
Yeah.
No others. But Mark, were you referring to the new restructure, the Assistant Secretary for Technology Policy?
Yes. So
Yeah.
I think there's links in the chat now. But yeah, ONC is being rebranded, and it seems like they're trying to centralize more of the AI and technology policy.
Right. All right. I think we are at time, but Jim, I see your hand up. If Randy, you have a second, we can address that question. But
Sure.
Yeah, I'll just take a minute to respond to Mark's. Yeah, for those who may have ever been familiar with HHS or had the pleasure to work at HHS, many of the activities go at the staff division level, which support the secretary's office. And then, of course, CMS, CDC, all the rest are optives. ONC has always kind of sat out to the side a bit in that structure. So by consolidating both things like the office of the CTO and creating a chief AI officer and the like, under the Assistant Secretary for Technology Policy, it takes a policy-oriented staff division role that works directly with the Secretary, just to give that a little clearer.
awesome. Thank you so
Thank
much.
you.
And thank you so much, Randy and Jacqueline. The recording should be posted on our website in a couple of days and should be shared with the community in the next announcement from Health AI Partnership. Thank you so much for your presentation today. It was really helpful. And thanks everybody for joining. I posted some links for the next presentation. We'll hope to see you there next month. Thank you.
Thank you.
Bye.